Thank you. Good morning. On behalf of myself, Judge Reardon, and Judge Young, welcome to our case call panel. We see some familiar names on our call today, and we understand that these cases are important to the litigants and counsel, and we assure you they are important to us as well. We've been diligently working on these matters. We've had the benefit of your excellent briefing, as well as the work of our research division and our chambers. We're familiar with the relevant facts and pertinent law, and we ask that you focus on your most salient points, keeping in mind our role. Finally, we're hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please substitute initials in lieu of using a victim's, petitioner's, respondent's, or minor's full name in those cases. With that, we look forward to hearing your arguments. We ask that you keep your own time, but I'll also be helping you with that. First case today, case number 1-372-286, People v. Chappelle.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Chappelle.
Good morning.
Good morning. Mr. Chappelle worked downstairs for the Unemployment Insurance Agency.
He's still working for them?
I don't think so.
Okay. I thought you said works as opposed to worked.
It was meant to be in the past.
Okay.
He, in the course of his employment, he was allowed to take vehicles from the motor pool and issued a state credit card to purchase gasoline for those vehicles. The allegation is that he committed embezzlement by using these vehicles and this gasoline for personal purposes. Initially, he was charged over $50,000. That was later amended to $20,000 to $50,000. And during the course of the trial, counsel made a lot of effort to show that much of those purchases were authorized for attending hearings in Southfield, for attending hearings in Farmington Hills, to serve subpoenas, to conduct investigation, and at the close of the people's proof, argued that there was actually no sufficient evidence to show that it exceeded $20,000.
Wasn't his whole defense that he didn't do any embezzlement?
That's
$0.
correct.
So what difference does it make?
Well, because he actually used the word 20,000 in closing in the motion, indicating that perhaps there should be room for the jury to consider a lesser included offense, embezzlement 1,000 to 20,000, which would be a 5-year felony instead of a 10-year felony, and which of course would greatly affect the amount of restitution which he was ordered to pay, which I think it was about $47,000. And so we believe that given the testimony, given the arguments, counsel was ineffective for failing to request that lesser included offense, which I think the jury would have considered and very likely would have found, which would have been inured to the benefit of Mr. Chappelle. So for that reason, along with 2 others, we believe that a new trial should be permitted. The second issue involves the disclosure of an administrative interview. This is something which was not part of the
There
discovery.
were notes, right? It
Yes.
wasn't an interview itself. He had the interview. He didn't have the notes, correct?
Correct.
All right.
And this is something that did not come out until the first day of trial through the testimony of one of the people's witnesses.
And the prosecutor didn't know about it, right?
No, I'm not suggesting that there was any hiding the ball, there was any misconduct, there was any attempt to suppress evidence. That's not the situation at all. They didn't know about it either.
Right.
But when it was learned, the very next day, that information was provided, and instead of suppressing that evidence, the witness was held back until the end of the people's proofs to give ostensibly counsel an opportunity to review that information and prepare to cross-examine that witness. However, this is a short trial, and I think learning about it in the first day, getting it in the second day, and then being responsible to conduct a trial while at the same time investigating newly discovered evidence, I think impose an unreasonable burden upon the defense. That evidence should have been suppressed. It should not have been allowed to be presented at trial. And again, not blaming the people, but the fact is it did not allow Mr. Chappelle to have a fair trial. There was an evidentiary hearing and there was evidence to suggest that there was that information, but for some reason it was not provided. But we don't believe the error was harmless beyond a reasonable doubt, that Mr. Chappelle was denied a full and fair discovery. And that's another reason we believe that he should have received a new trial. The third reason would be the civic duty argument, which came in closing. Now, and the quote from the Assistant Attorney General is that, quote, "Who is out the loss of money? Taxpayers."
Well, whose money was it?
Well,
It's my money, your money. We're paying taxes, right?
that's correct.
State taxes.
Yes, and
All
then the
right, so that's
jurors,
the taxpayers' money.
well, yeah, but the jurors are also taxpayers, and what the prosecutor was doing was making the jurors stakeholders in the outcome of this proceeding, and finding him guilty and of course resulting in repayment of the gas money and the depreciation or use of the vehicles would be a benefit to the jurors. It made them a part of the actually complainants in this action. We believe that this was unfair to Mr. Chappelle, that I think prejudice, it poisoned him, in the eyes of the jury. They're saying, hey, this is my money. I want it back. And so I think that was an improper argument.
Well, you got a good point, maybe. But where's the prejudice?
Well, I think that the prejudice is that he was denied his constitutional right to an impartial jury. And those are my three arguments. I think for all three of those, or any one in particular, Mr. Chappelle should receive a new trial. Thank you.
Thank you. You have plenty of time for rebuttal if you want it.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people.
Good morning.
Good morning. So very briefly, as it relates to issue one, Mr. Chappelle drove state vehicles approximately 175,000 miles, which based on the trial testimony amounted to about $47,000 worth of charges to the state budget through UIA, his employer. In order to make the claim that the embezzlement was really under 20,000, he would have to reduce those miles by approximately 60%. And if you look at the trial testimony, he drove these cars an average of 1,000 miles per trip. Like myself, my office is in this building. My office is down on the 10th floor.
You get a car?
No, I have to drive my own car to work. Now, if I drive to Lansing or Grand Rapids for argument, I can either take a state car or I can bill the state mileage. But I cannot charge mileage to drive to my job and to walk up 4 flights on the elevator. When he did that, approximately 1,000 miles every time he took out a car. So I think that belies any argument that there was.
Was he taking the car home or?
He was taking the car, and the trial testimony based on when he checks the car out and when he fuels the car, he's driving these cars everywhere. If you look at night, on weekends, on holiday weekends, there's times where he has multiple cars checked out at the same time. Part of his argument was that, well, I was using it for investigations and subpoenas. Some of the witnesses said that may have been part of his job description. Others say that it wasn't. But even saying that it is, when he checks the car out, he says it's for hearing attendance, not to deliver subpoenas, not to, quote, investigate these cases. Investigating wasn't part of his job. So I don't think, even had trial counsel requested that, he would have, there's no reason to have 2 cars checked out at once in any event, to have them checked out nights, to have them checked out holidays, and to walk a few floors to average 1,000 miles per trip. Detroit to, for example, the Mackinac Bridge is a little over 200 miles. So every time he checked a car out,
No, that's way over 200 miles.
he was going a couple each way. So he's driving the equivalent to the Mackinac Bridge and back 2 or 3 times. Every single time he checks a car out, when all he needed to do was get on an elevator to go, and I don't know exactly which floor his hearings were on, but it's, most of the hearings were in the same building. Some testimony, they may have been in Southfield or some of the other agencies, but that's still in the Metro Detroit area. That wouldn't justify an average of 1,000 miles every time he checked a car out, let alone explain why over Thanksgiving weekend, he drove a car a couple thousand miles on multiple occasions. And a lot of times there was trial testimony as well. He didn't even have hearings when these cars were checked out. So I don't think, even had trial counsel asked for the lesser included of instruction, I don't think it was rationally supported by the trial testimony. He was just using these as his own personal vehicle, which I think is what the trial testimony out. As it relates to issue 2, the discovery issue, he knew about the interview and he had the report from the interview. What was late disclosed was the email notes from an additional attendee that were then used to
Miss
create.
Washington, I think. did
Yes,
this?
and who was no longer, her testimony, she was no longer at UIA, so she didn't have access to the emails. So he had the gist of the notes initially. What he didn't have were the notes themselves. So
But you had the notes yourself.
prosecutor did not. No, that we don't have access to UIA's email system. As soon as Miss Ryan received those, she turned them over. And I believe even as Mr. Simon conceded, prosecutor wasn't aware of these, so this wasn't holding anything back. And he had the gist of the notes, basically the summary of the notes. What he didn't have were the notes themselves. So even as trial counsel conceded, it's quote, the more detailed notes that he didn't have. So I think the trial court's remedy, which was the hold this witness off a day to give you time to look at them, I think was not an abuse of its discretion. Like, it was just simply more detailed notes. He was able to cross-examine her in front of the jury about the differences, the contradictions in the notes about, well, he didn't answer most of the questions versus what he did answer. So I think that the jury heard were there any inconsistencies between the notes and the report itself. So I don't think the trial court's decision is an abuse of its discretion as it relates to the discovery issue. And finally, as to the third issue, I think what's important is in opening statements, trial counsel made the comment about Mr. Chappelle didn't have any financial gain from this. So I believe if you look at that opening statement, the trial testimony in Ms. Ryan's closing statement, essentially, I think you could say that his trial counsel's opening statement was really, this is a victimless crime. And I think what Ms. Ryan's, the prosecutor.
The money was budgeted anyway.
Yes, and so her closing statement about this is taxpayer money, she didn't say this is your money to the jurors. She just said it was taxpayer money.
Can you respond to Mr. Simon's argument that it tainted the jury?
And I don't think it did, because she's generally responding to the argument that this is a victimless crime. So that door was open, that it didn't taint the jury, because she didn't say, you know, juror number 2, this is your taxpayer money. She just said this is just taxpayer money in general, without emphasizing that, Your Honor, this is your taxpayer, Your Honor, this is your taxpayer dollars. It's just generally speaking, it's responding to the argument that there was no victim here. The victim was the state budget, which is funded through taxpayers. So, and I think that even trial counsel did not object to this. So if it's unpreserved prosecutor misconduct claims, it has to be outcome determinative. And I think going back to my first argument on issue 1, there is no, assuming that it's even improper argument, there's just no reasonable probability of a different outcome. Again, he was almost 200,000 miles on these cars, personal use, nights, holidays, weekends, multiple cars checked out at once, gassing these up all over the place at 10, 11 o'clock at night, multiple days in a row. There's no argument that even if the prosecutor, that argument was improper, that there would have been a different outcome here. So even if Your Honors find that it was improper argument, because it was unpreserved, there's no reasonable probability of a different outcome. Otherwise, I would just rely on my brief unless Your Honors had any other questions for me.
Thank you.
Thank you.
Thank you very much. This case is submitted.
Have a good day. It's gonna be a warm one. It's,
Next, we're calling number
go home
2,
to the basement.
373-333, People v. Perez.
Morning.
Good
Again,
morning.
Jonathan Simon on behalf of Mr. Perez. This was an incident involving allegations of domestic violence. Mr. Perez was convicted of assault with intent to do great bodily harm, which was the lesser included of the initial charge, assault with intent to murder. Argument 1 suggests that perhaps the people failed to disprove self-defense beyond a reasonable doubt, knowing and understanding that the burden is to show that a reasonable juror would not have arrived at that conclusion, and looking at the evidence in a light most favorable to the prosecution. So I'll move on to argument 2, which was Detective Gianola. She testified that as to an interview involving Mrs. Perez. And this happened 2 years earlier. She had no notes. She had no body worn camera. She she made a report, but that was hours later. She initially actually had very little recall. She had to rely, I think, upon her report. And we believe that it was prejudicial. It was irrelevant. It was only serving to bolster the credibility of the complainant. It was unduly prejudicial. It was cumulative. And we don't believe that given the sketchy recall and the lack of documentation to substantiate the testimony, that it should have been allowed. And this is preserved, and we believe that it is would I think generate grounds for new trial. As to argument 3, I don't think I have seen a single case involving Posey as to the reasonableness or proportionality of a within guideline sentence. But if there was one which cries out for some relief, I think maybe this situation. We have a 74-year-old man who has liver cancer, Parkinson's disease, cataracts, glaucoma, spinal stenosis. He takes 12 meds. He has anxiety. It has
But
absolutely
didn't the
no.
judge consider that? I read the sentencing transcript yesterday, and he was very sympathetic to his medical condition. He said that on the record. And he talked about the number of stabs. There were 34 stabs. He
I
said that's
believe so.
excessive. He said one's excessive, which I agree with him, but 34. And he then went on to talk about his medical condition. And, his age didn't excuse it.
Well, the guidelines were 29 to 57 months. He received a 36-month minimum, which was 7 months above the bottom of the guidelines. Still, I guess, within the bottom third. But we believe that given his condition, given the lack of any prior record, given the fact that the jury did not believe he intended to murder his wife, given the fact that there was some evidence that he too was receiving some abuse from his wife, we believe that the sentence is disproportionate, unreasonable, and that perhaps Mr. Perez should be allowed to be resentenced.
I thought he didn't intend to murder her. He said she was not going to leave the house alive.
Well, the jury didn't believe that he intended to kill her. They found evidence. They came back great bodily harm, less than murder.
Okay.
Questions?
Questions?
Thank you.
Thank you.
Thank you.
Good morning, and may it please this honorable court. My name is Madison Leonard for the people. I will briefly touch on each point or each issue raised by defense. First, the first issue being the sufficiency of the evidence to disprove self-defense. I'll be very brief and just acknowledge that this was a jury determination, and that the jury reviewing all of both the victim's testimony of her being threatened, the defendant threatening to kill her while she was seated and not addressing the defendant striking her in the head again while she is not attacking him, slashing her throat, stabbing her 34 times. Some of those stab wounds being while she's running away from him. There's stab wounds or stab wounds to her back, and the fact that she had her hand crushed as she is trying to escape the defendant. Her hand is crushed in a door and her fingers are broken. That combined with physical evidence of the injuries that she received that she was treated for while she was in the hospital, and evidence from her or testimony from her neighbor of the injuries that she was sustaining, or what that he could see that she had sustained right after the offense. I would argue that the jury received more than enough information to determine, for a reasonable juror to determine that the victim was in fact, or that the defendant was not in fact acting in self-defense. So with that, I'll move on to issue number 2, which is the issue involving MCL 768.27C and the statement that the victim made to a detective the day after the assaults. This was while she was, or I think either while she was in the hospital or she had just been treated in the hospital. And she spoke with this officer, this detective, and gave a statement describing the incident. That statement fell squarely within the requirements of MCL 768.27C as a statement made to an officer by a victim involving or describing a DV incident. The defense really highlights the fact that this was not recorded, and that there was no body-worn camera or recording. That is not a requirement of the statute. The statute requires that that this detective or an officer receives the statement, but does not require that it be recorded. There's no recording requirement. So I think that is a moot point by defense. The defense also highlighted that this is improper bolstering or vouching for the victim's credibility. I highlight People v. Robinson, in which this court, I believe, emphasized that it is important specifically in cases such as this, in a DV case such as this, for us to have an understanding of the credibility of the victim, and that it helps, these statements helped to determine the credibility of the victim. So the idea that it is some kind of, some form of improper bolstering is kind of lessened by the idea that credibility is highly important when we're talking about these types of cases. Does the court have any questions about this issue? Okay, then the last issue is issue 3, involving the fact that defendant argues that this is a disproportionate sentence. As defense acknowledges, this is a within guidelines sentence. The defendant, his guidelines were 29 to 57 months. He received a minimum sentence of 36 months. And as this court acknowledges, or this court asked, the judge did acknowledge during sentencing both as is the requirement under Milborn, both the circumstances of the defendant, the fact that he does have medical issues, pretty serious medical issues, that he is of an advanced age, and the court heard argument about the fact that this defendant did not have much of a criminal record at all before this. However, the court did weigh that, as the court was required to do, against the seriousness of the offense. As noted earlier, the victim was stabbed 34 times by her spouse in her home. Her hand was crushed, and she had to run to a neighbor for help because she genuinely feared that she was about to be murdered. So with that, the defense has not articulated a reason that this within guidelines sentence would be disproportionate. Does the court have any additional questions for me at this time?
No, thank you.
Thank you very much.
Any rebuttal, Mr. Simon?
Yes, briefly as to argument 2, certainly the people are right. There's no requirement under 768.27C that there be body worn camera. There's no requirement that there be contemporaneous notes. But or that the report be drafted, at contemporaneous as opposed to this one, which was later. This is something that the detective was called upon to testify 2 years later. She had limited recall. And so I think the thrust of this argument is that the recall was not sufficient to be, I think, meet the requirements of 28.76, 2768.27C, in that she, I think, to a certain extent, was speculating or grasping, trying to make a recall of something from 2 years ago. And to that extent, we don't believe that it should have been allowed, because it calls upon, I think, a great concern as to the accuracy of the recollection. And so for that reason, we believe that it was improperly allowed.
Thank you so much. We understand the arguments, and that case is submitted. Next, we're calling case number 3-375-061, People v. Bailey. We have one person endorsed for oral argument.
Good morning, may it please the court. I'm Joan Morgan. I'm here on behalf of Larry Bailey. This is a juvenile life or resentencing case. The succinct part of my argument is that this case should be remanded for resentencing, and let me try to explain why. Mr. Bailey was convicted of 5 counts of assault with intent to murder, 1 count of armed robbery, 1 count of felony firearm. At the resentencing a year ago, the trial court judge listened to Mr. Bailey's attorney's allocution and listened to the prosecutor's request for an above guideline sentence on both the assault with intent to murder counts and the armed robbery count. It's my position that Judge Baker Robinson made several errors in imposing the resentencing. First of all, when she initially imposed sentence, she indicated that it would be concurrent to another prison sentence that Mr. Bailey was already serving. And then when the prosecutor said, it needs to be consecutive, Your Honor, she said, okay, it will be consecutive. I think that raises an issue of whether or not she meant to impose a concurrent or a consecutive sentence. Ultimately, of course, she did impose a consecutive sentence, which increased Mr. Bailey's time in prison by decades. The other part of my argument is that the judge did not consider in any way either the Snow factors or the Miller factors. The allocution by the complaining witnesses in this case, I think, was very meaningful. I think it was very sincere. And I think what happened was the judge was persuaded by the allocution and therefore did not fulfill her role in terms of imposing a sentence as to either looking at the factors outlined in People versus Snow that indicate the judge should consider those in imposing sentence, and also not looking at the Miller factors as either neutral or mitigating. The judge absolutely considered the facts of the offense as an aggravating factor, although she did not use the word aggravating. It's clear that that's what she did. And at the end of the proceeding, she simply said, I'm going to adopt the prosecutor's recommendations, which the prosecutor admittedly indicated were above guidelines requests, both as to the 2 most serious counts. I shouldn't say 2 most serious counts. The most serious counts were both assault with intent to murder and armed robbery. The judge, in my opinion, did not use her discretion. She did not consider the appropriate factors, and she was unclear in her own mind as to whether or not these new sentences would be consecutive or concurrent. And for all those reasons, we're asking that you remand for resentencing.
Any questions, Judge?
Thank
Okay.
you.
Thank you.
Mhm.
That case is submitted. Next case is number 4. We're calling People v. Lakovic. We have one person endorsed for oral argument. Did I
Good
say that
morning.
correctly?
Good morning. William F. Branch, attorney for the defendant appellant. Okay, there is one thing, as I reviewed this, which unexpectedly becomes more important today than when I wrote the brief. I'm going to back up a little bit and then work into that. It'll just take me a minute. And as you know, of course, Mr. Lakovic or Lakovic, I'm sorry, I don't remember what the pronunciation was now.
You're in good company.
Yeah, I don't remember where the accent goes. But he's convicted following a second trial of criminal sexual conduct, second degree. Now, prior to the trials, the prosecutor filed a indication and application to use other acts evidence, and prosecutor specifically cited MCL 768.27A. And then the testimony that comes up at the trial, supposed other acts testimony, is to the extent that at one point, one of the young females was going from one room to another, and he grabbed her wrist and told her to move. She said in her testimony that it was nothing inappropriate, just made her uncomfortable. The other time, one of
I
the
thought he
young-
grabbed her waist.
Excuse me?
I thought he grabbed her waist. Am I?
I thought it was wrist. You might be wrong. You might be right.
Okay.
Let's see.
My notes say waist.
You have
The
Okay.
Marco Polo one is the more concerning.
the Marco Polo, even in that incident, female says it was part of the game. His eyes were closed. She concedes it was not, it may not have been anything inappropriate. His eyes were closed. His eyes were covered. Yeah, I agree with you. But his eyes were closed at that time. No action was taken. The other one involves something about a cake, and you're making a comment about one of the females getting a cake on her. Now, the point of all that is that none of these fall under the statutory definition of being either tier 1, 2, or 3 sexual offenses. And therefore, they should not have been used under 768.27A. In order for that evidence to be used, it has to fall under the definition in section 2 of the statute, which is goes
Do
on
we
to go through.
disagree with you on that? We think it could fit the statutory definition of some semblance of CFC. Should the evidence have still come in?
Well, as you say, then you disagree with me, but no action was taken. No charges were filed, which I understand is not necessarily indicative, but there was no evidence of any sexual intent. There was no indication of assault or sexual gratification. There was no other alleged illegal activity. So our position is, and I'm going to come back to something else on it, but our position is that it simply doesn't fall under 768.27A. It should not have been allowed. Likewise, the policeman who gets up there to testify in this case is asked kind of out of the blue to define grooming. Now, there hadn't been any testimony of grooming in the case. There hasn't been any, there was nothing, even the policeman testified, Detective Lalonde said, no, he wasn't aware of any allegations of grooming. And for some reason, the prosecutor asks him about grooming. The defense again objected to it, and it was allowed. Now, this becomes a little more important now.
Okay, if it doesn't fit a definition of CFC under the statute, could it have come in under 404B?
Would have come in under 404B if it had similarity to the actions that are actually relevant in this particular case. This particular case, he's accused, as you know, he goes into the one girl's room and rubs her while she's asleep. That's not similar to these other acts, to the other acts evidence. Texas, one of the girls by the waist or wrist, he makes some comment about a cake. This is not similar to fall under 404B. So no,
The action in the pool.
Well, again, the action in the pool, he's got his eyes closed. There's no indication that it was for sexual gratification. There's no indication of any intent at all except playing, I guess they call it, oh, the name has changed. It would have been blind man's bluff or something, when I was young, but there's no indication of any assault or sexual gratification there. Now.
Could it be, could it show a pattern?
Show a pattern if there was similar behavior, but there's
Seems
not
to be
similar
similar. They
behavior.
all seem to be sexual in nature.
Towards
But
teenage
there is no
girls.
evidence that it was. Even the,
Even the happenstance, that's a lot of coincidence.
even the girls, testified that there was no, they didn't review it as inappropriate. It made them uncomfortable, I think was the phrase that they used. It made them uncomfortable, but they didn't find that it was anything, inappropriate. Likewise, now the other allegation that's important and comes up is this thing about they're playing Pictionary. The mom is present and he comes up with a brilliant idea of who can draw the most realistic, picture of a penis. Well, I mean, that's a bad idea, but it doesn't fall under any of the CSC statutes. And the jury is exposed to this. So the jury hears all this. It's
So
not
your
just.
argument, it's more prejudicial than probative.
Yes. Now, something else I want to point out, though, that I noticed this yesterday. My understanding is the prosecutor did not file a response, any type of a brief in this case, besides not being here today. Now, these are fair trial or due process arguments, and the defense attorney raised these arguments at trial, so they're all preserved constitutional error. And we cite this case kind of in passing, which didn't seem very important at the time, the Chapman versus Californian People versus Anderson cases. Defendant is entitled to relief from preserved constitutional error unless that error is harmless beyond a reasonable doubt. The burden of proof lies with the prosecution. So on this issue, the fair trial issue and these questions we're raising, the prosecution has the burden of proof. Not only did they not show up today, which I can understand, they didn't file a brief. They forfeited this issue. So that's fine. You can say, okay, you disagree with me on the issue, etc. But the issue is forfeited under the law of both the federal and Michigan law. They've got the burden of proof. If I got the burden of proof and I don't show up to court, I lose that issue. Very interesting, I thought. Now, but I can hear you saying, wasn't it harmless error? Wasn't there enough evidence to convict him without this? Well, usually we have no answer to that, but this case we do have an answer to that. This fellow had 2 trials. The first trial, that evidence was not presented. The one girl, both the girls testified, but the female S, initial S, was not asked about these specific instances. The policeman testified, but he was not asked about grooming. Some expert witness testified about grooming. There was no objection to it, so that's the difference. The jury in that first case was out from 11 o'clock on the first day. At 11 o'clock on the second day, they said, we're hung. So they were out for more than a day, about a day and a half, hung jury. Second trial, this evidence is presented, about 2 hours, found guilty. So here we have an example that we can show it made a difference. That was the difference between the 2 cases. It might seem, you might look at this and say, well, those pieces of evidence don't seem that overwhelming, but evidently they were. That's the only conclusion we can come to. So in the second trial, the safeguards that assured a fair trial were violated. These findings of guilt should be set aside. That's all I have.
Any questions?
I have no rebuttal today. I can't give you any rebuttal.
Any questions, Judge?
No?
Thank you.
Thank you very much. That case is submitted. Okay. We're moving on to number 5, People v. Davis. We have 1 person endorsed for oral argument. Good morning.
Good morning, judges. My name is Robert Tomac. I represent the appellant Eddie Davis. In this appeal, we are arguing that there was insufficient evidence of gambling violation. Now, the prosecutor has indicated in their response that first of all, they would deny that there was insufficient evidence. However, the fact is, this fake bill was not accepted. And so there was no money recovered.
Didn't
due
he
to
say that the bill came from the casino in the first place?
That's what he said. I can't figure this case. He was an experienced gambler and he had everything in the world to lose by putting in I think it even said play money on it. I just don't know. I can't figure how this would have happened.
Seems to me it's like, this is more of like an attempt case.
Well, okay, I'll get to that now. So our argument for insufficient evidence is based on that fact that the bill was not accepted. Now, the
And he
prosecutor.
set it aside. He gave him what, there were $1,500 bills and he gave him chips for 14.
Yeah, one of them was $100 bill, and she
No,
said,
they were all $100.
well, the fake one was $100 bill.
Right.
They're all $100 bills, and one of them was play money, and the dealer set it aside. So, our argument is for insufficiency is based on that fact. Now, the prosecution in their response indicates that a resolution for this court, or what this court might do, is remand the case for the ministerial task of imposing a conviction for attempted.
Yeah, can we do that?
Okay, well, I don't think you can, and I'll try to explain why here. Here's what you run into. There's two sections here. One that they rely on for culpability or liability. One is that there was a attempt that there was cheating. This is under the subparagraph F of the gambling statute 432.218. And the other one is under subparagraph J. Now, the prosecution says that under subparagraph F, it should be remanded, and a charge, the information, or a charge imposed, or a conviction imposed for attempted cheating. And likewise, the prosecution argues as to subparagraph J that language there does include attempt. So, but here's the problem with this. We don't know under which subparagraph the jury found.
I agree with you there.
Yeah.
So what, could we remand it down and for a retrial on attempts? Is that permissible?
Well, I think the resolution is.
I know the resolution you want.
Okay, without amendment, without a remand. And let me explain why. We don't know under which subparagraph the jury found him guilty. So if you were to remand.
We don't. I agree with you.
Yeah.
We don't know what he was,
Right.
but,
So if
so we can't order the trial court to change the conviction to attempt, I don't think.
Well, yeah, I'm glad to hear that. If the court was to decide that they could under subparagraph F, that's one thing. However, like I said, you don't know under which subparagraph they found him guilty. Now, under subparagraph J, this is interesting.
If we did remand it, is there a double jeopardy issue?
I looked into that. I didn't find that to be fruitful.
Okay.
But here's the thing. Under subparagraph J, you can't remand that for and impose a conviction for attempt, because that subparagraph was not violated. And the reason it wasn't violated is because a wager was made. He made a wager. If you make a wager under that subparagraph, then you're not liable you're not liable for that, for a violation of that paragraph. And where I get this from, didn't find any Michigan cases, but there's an Iowa case, Iowa versus Mitchell Terrell Smith, number 08-1757, dated October 7th, 2009. And it says they have a statute exactly the same as our subparagraph J.
Well, I don't think you need to go to all that
Yeah.
trouble. They didn't accept the bill, so.
So the argument is it doesn't fit under J because it says without having made a wager contingent on winning.
Right. So, I
Our
mean,
argument is your client made a wager contingent on winning.
right.
Problem is the wager included a fake $100 bill. Or do you think that that was not the
No,
wager?
the bill is, there was nothing gained from that. There's nothing gained from him presenting that bill because it wasn't accepted. But here's another thing that case held.
But he did seem to me, he attempted.
Okay, you
There's an argument that he attempted because there was a bill presented and the bill was set aside.
there's an argument under subparagraph F. You can easily do that. I mean, it makes sense that you could.
I'm very interested in the answers to the questions about double jeopardy and, the resolution here.
The rest of, okay, well, okay, what I'm saying, okay, like I said, I looked into double jeopardy and I didn't find that fruitful. But
You didn't find that fruitful. Do you mean that double jeopardy, that should this court remand and say, yes, there was insufficient evidence that this individual committed a felony under MCL 432218, can the prosecutor bring new charges and say this individual attempted to commit a felony?
okay, for the record, I'll object. I'll state that there could be a double jeopardy issue if it's remanded. I admit I didn't.
Oh, you
look-
want that argument on your side. but
When
I thought
say
you
it's not
said,
fruitful,
I thought
you're
so
not
too.
You don't know, you don't know.
No, I don't.
Okay.
As to
Okay.
double jeopardy.
Thank
But-
you for
but-
that clarification.
But I really want to get this point across as to subparagraph J. I mean, I think that the reading of another jurisdiction's statute that has the exact same language is helpful because I don't find a case where they go into the language of subparagraph J. And also in that opinion, they said that when you talk about winnings, they're only talking about winnings that were legal. In other words, that paragraph, subparagraph has to do with you can't have a liability unless there's no wager made. And the winnings that are talked about in that subparagraph don't necessarily confine themselves to legitimate winnings, but whatever winnings there were. So I don't know if I'm making myself clear here though, but the conclusion here that I want to get across is if the court were to consider this, remanding this, court would have to consider, well, under which subparagraph was he convicted? And you might say that under subparagraph F, we can simply say that it was an attempt. But you cannot say that as to subparagraph J because there was clearly no violation. You can't say there was an attempt. There's no violation because he made a wager. So then you'd have to decide, well, are we going to rely on subparagraph F and say, all right, he's convicted now of attempt? Or are we going to rely on subparagraph J, which means there can't be a conviction for attempt? And like I keep saying, we don't know under which one the jury decided. So that would be that would not be an impartial analysis. You'd have to, because you don't know which one. You can't, if you were to decide, say that it was subparagraph F, and okay, we'll make that a attempt. Then you're like putting your thumb on the scale for the people. I hope that's clear. I hope, but I think that, if the court would take a look at that, Iowa case, it would be helpful in interpreting subparagraph J. That's our argument, judges.
All right, thank you
Thank
very
you.
much.
Well, we'll roll the dice.
All right, that case is submitted. We're on number 6. That's 372-213, People v. Zibowski. We have 2 people endorsed for oral argument.
Morning.
Morning.
My name is Barton Morris. I'm the attorney on behalf of the appellant. The appellant's name is Bukowski. I guess that Z is just silent.
Oh, thank you. Are you saving any time for rebuttal?
I don't think it'll be necessary. I have 4 points in my brief. I'm only going to address one of them, and should I be more eloquent than I anticipate, then perhaps I will, but I doubt that that'll be the case. This is a case where the defendant was convicted after a jury trial for operating while intoxicated, causing death and second-degree murder. We have, as like I said, I filed a brief identifying 4 issues. I'm going to confine my comments to the first one and rely upon my brief for the following 3. The first one was challenging the fact that the trial judge denied the defense counsel's motion for directed verdict after challenging whether there was sufficient evidence necessary to find whether there was a second-degree murder. That motion was denied. The defendant was convicted after a jury trial by the jury of both charges. And case law in Michigan is clear that, of course, when a death is involved in a drunk driving case, that second-degree murder can be a conviction offense, but only under extraordinary circumstances or egregious circumstances. There has to be malice. And in this case, that malice will necessarily have to be imputed or intended, or I should say, imputed, because the malice in this case, or in all of these cases, nobody really goes out and intends to kill somebody. It's done with that malice, which in this case is a willful and wanton act in disregard of the likelihood that the tendency of that behavior would be an injury or death.
The failure to press the brake and driving over 15 miles per hour over the speed limit enough to imply that requisite malice?
And my answer is no, that is not enough. And of course, that is what the people and of course the judge in this case had ruled. That is not enough. As the controlling case, I believe, in this for this issue is People versus Gotke, United States, excuse me, the Michigan Supreme Court 1988 case, where that court illustrated a number of different cases, Baker and Hodkinson, and they enumerated the numerous facts that can contribute to that type of finding. And I find when looking at all 3 of those cases, there is one overriding fact.
Well, wouldn't getting behind the wheel of a car with a blood alcohol level of more than double the legal limit be evidence of reckless disregard?
No.
No?
No. It's certainly bad.
It's
certainly
really bad.
It's, yeah, absolutely. There's no question about that. All drunk driving is bad. I mean, even the legal limit can kill somebody. So
But
just
this
the
is
fact that somebody has a illegal limit.
And then running the red light 13 seconds after it changed?
Absolutely.
Pretty
Bad.
bad. And we have to look at this in a light most favorable to the prosecution, correct?
Yes.
I think some of the testimony was that he floored it.
There was testimony that he sped up. Yes, that was the evidence. But what we also see in these cases that I just identified was that in all of those cases, there was evidence that demonstrated that the defendant in those cases disregarded things that happened preceding the accident. For instance,
Well, your client, excuse me, disregarded the drunk driving laws, disregarded numerous traffic laws. That's not enough disregard?
the appellate courts have clearly stated that it's not enough, that there has to be egregious conduct. They're not just bad conduct, not conduct that results in a
What's
death.
egregious conduct?
For instance, in Goki, that individual was evading police after being ordered to pull over, knowing that he's intoxicated. So now he has elevated his level of malice because now he knows he's intoxicated and he's evading police, significantly increasing the likelihood that there's going to be an accident.
I mean, I understand what you're saying, and I agree with you that being drunk is not enough. But 13 seconds, going through a light and hitting the gas pedal to the floor, nearly avoiding another accident that was only avoided because the other driver coming through the intersection saw him and just stopped instead of going through when they had the light. I just think it's the totality of the circumstances that you're fighting against here that show that there was like a malicious disregard for life.
I understand, certainly. And
It's a tough set of facts.
yes, if anytime there's a death, of course, there's going to be a tough set of facts.
That's fair, yeah.
And anytime there's a drunk driving, there is a opportunity or possibility that somebody is going to get injured. And so the law really here is to what degree or what level must a level of evidence overcome in order to impute that level of maliciousness. And that is where I argue that in this case, that level had not been reached because we have an individual who has not ever been prosecuted for operating while intoxicated before. He was not evading police or doing something. And yes, running a red light at a very high rate of speed, it's certainly bad, but does it rise to that level of maliciousness where we're going to impute such a significant penalty and such a significant not harsh, but just more serious case? And that in this case, no, I don't believe that happened. In the Baker case, it was more than just the high BAC and speeding and running a stoplight. They said that in that case, they had a very good familiarity with the scene of the accident. And Hodgkinson, the arguments were that not only was the individual more than 2 times the legal limit, but he had prior accidents, had actually backed into a car on 2 separate occasions, putting himself in a position where he should have known that he is a significant danger to himself and others, and property injury and killing somebody. Yet he still went out and did it anyway. Mr. Bukowski in this case was not running from the police. He was not. His levels or the evidence in this case doesn't rise to that level, and it is for that reason I believe that there was error in this case, and I'd ask this court to grant our relief. Thank you.
Right, thank you. You have plenty of time if you want rebuttal.
Good morning, Your Honor. This is Jonathan Mysick on behalf of the people in this matter.
Good morning.
I will address council's oral argument and then rely on my brief for the balance and also address any questions that the panel has. But this isn't just a drunk driving case, and I think that your questions have pointed that out quite succinctly, that this wasn't just a drunk driving case. Defendant was at over a 0.18 BAC. I think that qualifies for super drunk. So he knows exactly, and so objectively we know what his BAC was. Moreover, counsel relies on Gecki saying that there has to be this that there has to be a police chase and a knowing that there was that the defendant was knowingly drunk in order to get to that egregious level of circumstances. Well, certainly we don't have a police chase in this case, but certainly you know that if you're driving, that you shouldn't be driving drunk. You should be, you should not be disregarding traffic control devices. You should not be driving, not just speeding, but excessively speeding, 73 in a 45 zone. And so certainly we can analogize a disregard for the law in that regard. And then as far as knowing knowing that you're drunk, well, we have evidence in this case that the defendant knew he shouldn't have been drinking. He knew he shouldn't have been driving. He told the police that he had a drinking problem. Saying that you have a drinking problem would allow a rational trier of fact to conclude that not only does he know that you shouldn't be drinking driving, but he knows the effects of alcohol on a person in general, but he knows the effects of alcohol on him.
Well, let me kind of differentiate some of this, some of these facts that you're providing, because some seem relevant and some don't. So the cases that Brother Counsel cites are stand for the fact that drunk driving alone isn't enough, which you don't contest.
No, absolutely not.
So does it even matter whether you're drunk or super drunk under the standard that drunk driving alone is insufficient?
Well, I think that it's, as Judge Maldonado indicated, that has to be taken into consideration under a totality of the circumstances. Certainly, certainly when you're drunk and you're drunk driving, you're drunk. You shouldn't be driving. You are impaired. You are a danger to yourself and others. Especially when you're voluntarily intoxicated, and you know what the effects of alcohol are. So, regardless of, and so it's a situation where yes, he is drunk. And yes, it is important, and I think that it's important to know that it's not just a situation where he was drinking and was drunk. He drank to the point where this is just a classification of the level of the BAC.
Let me put it this way. He has the same BAC, okay? He has the same knowledge that he has a drinking problem, but there's no traffic violations. And in the standard course of going, somebody dies in a collision. Do we have enough for malice then?
In your hypothetical, if it was just the 0.18 or higher, I would think that it'd be operating with a high BAC causing death. I don't think we get to murder too, if it's just the drinking alone. But
because the other piece about understanding that you have a drinking problem, understanding that drinking is, that you have an unhealthy relationship with alcohol, that it's illegal to drink and drive. I question the relevance of that.
Well, in that context, perhaps it would even qualify as a reckless driving causing death, and that you're understanding that there is a danger, that you know the effects of alcohol on you and others, in general, and on yourself, and so then you are willfully disregarding that action. So again, just with those two factors, no, I don't necessarily think you get to murder too. And I think that, and because as Brother Counsel said, and we all agree on that for murder too, you have to have that extraordinary egregious circumstance, which we do have in this case, because it's not just the drinking, it's not just the drunk driving, it's not just the high BAC. It's now we have the added in, now we have the manner in which he is driving. We have the speed, the increase in speed from 61 to 73 in the 45 zone. We have the narrowly missed crash. We have the failure to excuse my stutter, to stop at a red light that had been solidly red for 13 seconds.
Yeah, I think that's the most damaging piece of evidence, because that's, to me, I mean, he was speeding very fast. That is true too, but the light was red for so long. You can't, if it had been yellow, I'm not sure where I'd land today.
And to bring it back to the cases relied upon by Collins counsel, the named defendant, Gaki or Goki, he was evading police, but the other named defendants like Baker, that Baker's circumstances were virtually identical to the ones present
Correct.
here, where he's going 60 to 70 in a 35. He failed to stop at a red light. Now it's a slightly different legal question. It's, can this conviction for second, well, I guess it's actually identical. Can this conviction for second degree murder stand?
Absolutely
And,
can.
and the court held it could.
Yes. And so Baker, and I pointed out the Baker case at pages 9 and 10 of my brief. And
Great.
so, yes, as this court has held in the past, these facts are, Baker's on point. And so unless the court has anything further,
We don't.
all right, thank you very much.
Sure.
Thank you. Should have mentioned it earlier, but I did note in Pelley's brief, they referred to a case called Albert. And I think that it was probably analysis to the facts of this case, but it was a different standard in that the court was reviewing whether there was a proper bind over an abuse of discretion from the district court to the circuit court. And so I wanted to just bring that up because I don't believe that it was appropriately argued. And I would lastly just say that if somebody's at a 0.18, generally people don't know that they're at a 0.18, right? Like most people don't have a bodily alcohol or a breathalyzer in their car so that they can see, oh yeah, I'm at 0.18, I'm going to go and drive anyway. That's just not what happens. People generally don't know. They know they're intoxicated. I think that, or at least they can know, should know, but they generally don't know where they're at. They just know that they shouldn't be driving. But I think that's with anybody that is really driving a motor vehicle with an unlawful bodily alcohol level. Thank you.
All right. Thank you very much. That case is submitted. The next case we're going to call is number 7. That's 372-503, People v. Brigola. We have 2 people endorsed for oral argument.
Good morning. May it please the court.
Good morning.
Ian Kerfall on behalf of Mr. Briggelin, reserve a couple minutes for rebuttal.
Thank you very much.
So in this case, we have a search warrant that lacks any indicia of probable cause whatsoever. The search warrant is based on information from a CI and from what we have as a trash pull. Turning to the CI here, if you're going to use a CI in a search warrant, there's got to be some indication of the veracity of the CI, some basis to where the CI got his knowledge from. Basically, what the CI is providing is reliable. In here, at most, what we have is the CI provides some information. Mr. Briggelin lived at 351 Squirrel Road, and the officer confirmed that through observations, through background checks, and I guess just sitting there.
We saw him coming and go.
Sure.
Correct.
The issue, though, is the CI also says, Mr. Briggelin is dealing with controlled substances there. And what we don't have is any indication of where the CI got the information from. Was it based on personal knowledge? Did he see Mr. Briggelin dealing in controlled substances? Did he see people in there using them?
Why does that matter after the trash pull?
Yes, thank you. So going to the trash pull here, the trash pull is also problematic. And the trash pull, we found some amphetamine meth that field tested positive. We also had in that trash pull in that bag, there was a scale and some baggies. But critically, in this probable cause analysis, is there's paperwork in there, not the 351 Squirrel Road, but the 3052 Eastwood. So what was found in the trash pull, the bags, wasn't actually tied to the residence. It was tied to a different residence.
The fact that it was, remind me where the trash was located that was pulled.
351 Squirrel.
Okay, so it was pulled from that residence though, right?
Yes, but inside the bag was paperwork indicating it belonged to a different address of 3052.
Okay, so
Those
for,
I'm sorry. Are you arguing that 3052 brought their trash down to 351?
Perhaps, yes.
Huh. Okay.
Well, how else did it get in there?
Because it was in the house and they brought it out in the trash.
From 3052.
No,
Eastwood.
351.
We didn't have any evidence of that.
but we're.
It's
but
in the
we're-
trash from that house.
Yeah, but we're at probable cause and it's in front of the house.
Yeah, it's their trash can.
Okay, all right, and we don't know how long it's been in front of that house, right?
I'm sorry?
We don't know how long it's been in front of that house. There's no indication in the search warrant that, hey, I saw them pulling this trash container out. 2 hours later, I went and searched it. And speaking of the or the methamphetamines found in it, at trial, we had evidence that Mr. Brigglin had a valid prescription for Adderall, which would feel test positive for methamphetamine. So we also have the issue of the fact that a valid prescription for Adderall or meth or amphetamines, I'm sorry, is that enough by in itself to say there's illegal activity going?
If we weren't at probable cause, I might be able to hang in there with you, but the standard's so low.
Well, marijuana is legal now, so let's switch it to marijuana, right? Would that be enough to go in there knowing marijuana is legal if we found a roach in the trash bowl?
With scales, with a scale and with other paraphernalia, yes.
You mean the corner baggies and the digital scale? Okay, well, I think it's problematic that we have an address that doesn't match 351 Squirrel Road. We don't have anything indicating when this trash was taken out, right? That goes to the staleness argument. The trash could have been sitting on it for days. We don't know. That's not in the affidavit, so we don't actually know that. And combined with we don't have information on the CI or whether he's credible, verifying anything of that. So I would argue just that in of itself is not probable cause. Then we're executing a search warrant, we're going to find evidence of controlled substance inside the residence. Turning to the second issue, the plea negotiations. Submit an affidavit with my motion for a new trial. The prosecution submitted an affidavit too. Primary issue was, what was the advice concerning if I plead guilty to felony firearm on this case, how's that going to affect my sentence on these other cases I have pending? Mr. Brigglin indicated that he was told, if you plead guilty to felony firearm here, it's going to run consecutive to everything else, right? So if you're getting to another case, 2 + 2, you're going to do 4 here. Certainly the plea offer was just to plead to the felony firearm. Under the law, that would run concurrent to anything else, any other cases that's floating out there. So in his mind, it was like, well, if I'm going to do 4 years anyways, I might as well take this to trial, was his mind. And we filed the motion for a new trial. The prosecution had an affidavit from trial counsel. We had conflicting affidavits. Trial counsel said, no, it's not true. I never, advised them of that. In response to that, I did, in my motion to remand, file a much more detailed affidavit in that regards. But I think we have here an issue of what was the advice concerning this felony firearm, and what were these discussions between trial counsel and Mr. Brigglin concerning the plea, the effects of the other case on his plea, and decision to go to trial. I think with the conflicting affidavits, we should have had a evidentiary hearing on this issue and asked the court to remand back for that. Turning to the other issues, the trailer, the house was, I know the court asked for the body cam. It's very cluttered, right? I mean, there's stuff all over the place in this house or this trailer. And we have here is a situation where the methamphetamine that Mr. Brigglin was charged with was found inside a ceramic mushroom underneath.
In his office.
In an
Right.
office, yes.
In his office, correct?
An office he used. He also indicated other people use the office. But here's a critical issue is, just being near drugs in itself isn't enough. You have to know it's there. So I would argue if something is hidden inside a ceramic mushroom like that, we need something more than he's just near it to indicate he has knowledge that there is in fact methamphetamine inside the ceramic mushroom. The same goes for the cocaine that was found inside a container, inside a stack of drawers. The same thing goes for the gun that was found. The pills, he acknowledged the existence of those because he would dispense them to Mr. Cooper, is what he said. And I would, advise the court, I know he indicated in a statement to the police, I know people here, they use drugs. And we indicate there may have been methamphetamine in the house. It might have been the methamphetamine that was found on the table in front of that one individual when the police searched the house and somehow didn't charge that individual with possession of methamphetamine. But certainly there's no connection that would show Mr. Brigglin had knowledge that there was methamphetamine inside the ceramic mushroom. And I wonder if they would even charge him with it if they had found him in the kitchen when they came into the trailer. So I don't think just his proximity to the methamphetamine or cocaine is enough in that regards. Turning to the oxycodone and alprazolam, the A, first going to starts with an A.
I'm not going to help you out there.
Alprazolam, right? here's some evidence indicated that Mr. Brigglin was dispensing it to Mr. Cooper because he was afraid he was going to eat them all and use them all. And trial counsel asked for, special instruction that basically said, hey, I think the jury needs to be able to find I wasn't no legal right to possess. And what trial counsel was trying to get at was like, hey, look, the person can be a vessel in dispensing someone's medication. And shouldn't it be a crime, right? I don't think the legislature ever intended that. And I would use a hypothetical, right? Hypothetically speaking, because there's prosecutors here in the past, right? Family members may have asked someone to go pick up their prescriptions for them because they're incapacitated to. So I don't think the legislature would, want those incapacitated persons driving to the pharmacy to get their prescriptions. They would send someone else. And certainly in the past, maybe these persons have said, hey, can you go grab my Vicodin for me so I can take it? I don't think the legislature was ever going to criminalize that.
I think it could be both, right? That can happen. And if the person who's possessing grandma's Vicodin gets pulled over, that could be a problem for them legally. I think it's common practice to help someone out who needs help, especially someone with a history of substance abuse disorder, so that they don't take all their medication at once. But that doesn't then also mean this is legal to assume that role as a layperson.
As a layperson on probation.
Right.
But I think regardless, it should have been for the jury to decide, right? Is this legal behavior? Because where do we draw that line at, right? I mean,
But that's a legal question, and it's not legal to just assume the role of like a in-home nurse. And it happens all the time, and it's morally maybe even good or great sometimes, but that doesn't mean it's legal. That's not an open question.
Well, then hypothetically, someone may have committed some crimes back in the past, if that's the court's position. And again, I don't think the legislature would have attended that, and whether or not the prosecutor would charge that, that was the actual what was going on. But I know I cited to an unpublished case, SOSER here, and I would just point out this panel never said, hey, look, that's not a defense, right? You being a caregiver, you picking up these meds for this person, it's not a defense. So they send it back to the trial court for a hearing. So I think at the very least, this should have been left up to the jury to decide here. Moving to the sentencing issue, OV14 scored at 10 points here. There's no evidence here that Mr. Brigglin was the leader in the situation, that he guided, directed, led these people to use whatever drugs they were using in this house. You had proof of residency for multiple people in this house. When the police entered the house, you had one of the co-defendants who had also lots of drugs in her purse. Mr. Brigglin wasn't charged aiding and abetting, maintaining a drug house, wasn't charged with delivery. He had no co-defendants to what he was charged with. He was charged with mere possession. And I don't think the fact that you just reside there, let other people use drugs, means you're the sort of the guiding hand in them using the drugs. And there's no evidence that he gave them anything, forced them to use anything. I think you need more than just, yeah, I know they're using. I think you need a lot more than that. And I know I cited to an unpublished case again, but in there they said that was enough for leadership position. There's far more evidence in that case of this person being the guiding hand in distributing drugs. So I will, unless the Chris has any questions, I will come up on rebuttal if necessary.
Judge Reardon? Thank you. You have time for rebuttal if you need it. You're welcome.
Morning, Your Honors. Brianne Ruddy, Assistant Prosecuting Attorney, appearing on behalf of the people of the state of Michigan, Oakland County. I'm going to primarily rely upon my brief with regard to the first issue with the trash pull. I think the court recognizes where I stand on that, and I believe that the court understands my argument quite well in that regard. Just to mention briefly about the office and whether or not it was his, Judge Maldonado, you pointed out that it was his office. All of the drugs were found in his office. Defendant even admitted that when he was first talking to the police at the very beginning, he said, it's my office. And then later on, I think it finally dawned on him, oh, wait, I have to say it. Everybody had access to it. That did not come in until later on. I think what he said at first, that it's my office, was the actual truth in that. And that is part of the record. And then finally, just with regard to the holding of other people's drugs. I think we know that that is not, like Judge Young pointed out, that's not legal. It's also not legal for us to go 75 in a 65-mile-an-hour zone. Sometimes we do. But you have to look in drug cases, we always look at the totality of the circumstances. So if I'm on vacation with my 85-year-old mom, or better yet, if Judge Reardon's on vacation with his wife and he has a prescription, but he doesn't carry a purse and his wife does, under those circumstances, if his wife is carrying his medication, that's one thing. But in this case, first of all, there wasn't that relationship. They were not together. And it's completely different under the totality of the circumstances that defendant, a fellow drug user, a fellow drug addict who's admittedly been having a drug problem for quite some time because of his accident, is holding medication for another drug addict. I think the totality of the circumstances can lead us to that logical conclusion that, yeah, that was not him handing out his meds so that he could take it. That is a matter of defendant getting his hands on those drugs and either using them himself or handing them off to other people. So I don't think that we can use that, hey, it's okay for me to pick my sister's medication up at the pharmacy and if I get pulled over, yes, of course I am in a situation. I agree, Judge Young, but I think that we have to look at everything, the totality of the circumstances. Am I holding my own drugs? Am I holding, do I also have groceries from Target along with that? And then am I handing it over? Or is this something where it's months later, days later, when we're not even in the same vicinity and those drugs come in? I think with regard to the rest of the arguments, I'd be happy to take any questions that the court may have for me.
Thank you very much.
I have no rebuttal argument unless there's questions.
Any questions?
Thank you.
Okay. Thank you, Judge. Stay
Thank you.
cool.
Have a
Thank
good
you
day,
so
guys.
much. You too.
Stay cool.
It's
Yeah,
hot out
we're
there.
pretty cool.
Judge Reardon. All right. That case is submitted. We're going to move on to number 8, which is 373-801, People v. Wilson. I have 2 people endorsed for oral argument.
Good morning. May it please the court, Richard J. Goodman, appearing on behalf of the defendant appellant, Elijah Wilson. In light of the facts and the issues raised in this argument, I'm going to rely on my brief unless there are any questions by the court.
Do you have any questions, Judge? I don't. No,
Thank
thank
you.
you very much.
Your Honors, Jonathan Mysek on behalf of the people, standing in for the prosecutor of record, Ms. Nancy Zaya. Like brother counsel, I would rely on the brief previously submitted and yield for any questions.
Any questions? None. No, thank you very much.
Thank you.
All right, that case is submitted and we're going to be taking about a 10-minute break. Thank you for your patience. I know that was a little bit longer than 10 minutes and I apologize for that. Okay, so we are on now. We're finished our 10 o'clock hour and we are moving on to the next set of cases, the 11 o'clock cases. We're going to start with number 9. That's 375-437 Camper v. White, and all the same admonishments from the first session stay in place. We have one person that is, are they by Zoom? Okay. That case then is submitted and will be decided on the briefs. The next case is number 10. That's 371-189 VHS of Michigan, Inc. versus Farm Bureau General Insurance Company of Michigan. And we have a panoply of people. Okay.
Good morning, Your Honors. Nathan Sherbarth on behalf of defendant appellant, the Michigan Automobile Insurance Placement Facility.
Thank you.
I'd like to save a few minutes for rebuttal. I don't anticipate using all my time, and I do appreciate the court's willingness to allow me to appear remotely on short notice.
About
Uh,
five,
Thank you.
five- I'm sorry, about 5 minutes for rebuttal, did you say?
Oh yeah, 5 minutes will be plenty. I don't anticipate using anywhere near the full time.
Okay, thank you.
Thank you, Your Honor. In this case, it's undisputed that Isabella Lusby was a resident relative of Audrey Lusby. She was a pedestrian involved in a motor vehicle accident. Audrey Lusby, her grandmother, purchased a personal protection insurance policy with an opt-out under 3107D from Farm Bureau, and that policy was in effect when the accident occurred. So the dispute in this case boils down to the MAIPF's role or lack thereof under the circumstances, given that this opt-out policy was issued and did not provide allowable expense benefits. Simply put, the fact that Audrey Lusby opted out of allowable expense benefits does not mean that there was no applicable personal protection insurance coverage available as defined under 3172, such that Isabella could claim benefits through the MIIPF.
What do we do about Northland Radiology?
Well, Your Honor, I think that it could control here. I don't think that well, it does control. And under Northland, the MEIPF is still out of this because there's no dispute that Isabella wasn't disclosed. Audrey Lusby did not disclose Isabella. She did not have qualified health coverage, and regrettably under Northland, that means that the Farm Bureau policy should be treated as unlimited. And under the circumstances, 3172, there is applicable personal protection insurance available through Farm Bureau, and MEIPF is out under either circumstance. I'm happy to elaborate more, but frankly, under either circumstance, whether under the plain language of the statute, it seems like the trial court here was confused about the fact that the Farm Bureau policy didn't specifically list Isabella, but she would still be able to claim through that policy under 3114 sub 1. And under the circumstances, whether she's entitled to unlimited PIP benefits based upon the Northland and effective election of 3107D sub 4, or under 3114 1 generally, there should be no dispute here that the MAIPF has no role in this. This is a dispute between VHS and Farm Bureau, and the MAIPF should have been dismissed as a matter of law. I'm happy to answer any questions. Otherwise, I'll save my time for rebuttal.
Any questions? All right, you have plenty of time for rebuttal.
Thank you, Your Honor.
I believe it's morning still, so good morning. May it please this honorable court. Brett Mellon for the plaintiff appellee, VHS doing business as DMC. As Judge Roridan said, sorry if I mispronounced that, Northland clearly controls here. We submitted a supplemental authority citing Northland, and this case here is controlled by the decision in the published decision in Northland Radiology v. Allstate, decided March 25th, 2026, docket number 374214. The facts in Northland and this case are materially identical, and Northland resolves the issues in favor of the MAIPF, meaning that Farm Bureau's policy was ineffective, which allows for unlimited PIP coverage on the Farm Bureau policy. Just like Northland, this opt-out was clearly ineffective. Resident relative Isabella Lusby, DMC's patient here, was covered only by Medicaid. This is not qualified health coverage. Therefore, just like in Northland, the opt-out was ineffective and the policy provides for full unlimited PIP benefits. On that basis, we ask that the court reverse and remand the trial court's ruling. Are there any questions?
No questions. Thank you.
Thank you, Your Honors.
Not much to rebut. Oh, sorry. I didn't realize that you guys were splitting your time, but you have plenty of time.
Nice to see you, Ms. Paglio.
Judge Reardon, thank you.
This is Judge Murray's old law clerk.
Oh, welcome.
I shouldn't say old, former law clerk, very young law clerk.
Thank you. Very gracious. Good morning, Your Honors. May it please the court, Olivia Palia appearing on behalf of Appley Farm Bureau. We have some stuff to talk about. As you
Sounds
guys-
ominous.
Yeah, as you know, Northland Radiology came out in 2026. I believe it is factually and legally distinguishable to this case and should not be applied by this honorable panel. First of all, this case involves a pedestrian, making it factually distinguishable and implicating 3115. On the legal side, when you read Northland Radiology, it only discusses the second half of 3107D. The criteria it speaks to that should be met by an applicant before they can even make an election. But it does not address my briefing, which is on the first part of 3107D, and that is how an effective election is made. An effective election is made per the statutes when an applicant makes the election in the manner described in 3107E and on a form approved by the Department of Insurance's director. That is what happened in this case. Now, I understand Northland Radiology purports to say the criteria must be satisfied, but the statutes, when you read them, say an effective election is governed by the first part of 3107D, which refers to 3107E and says the election must be made in the way described under E and on a form approved by the director.
And that
I
sounds
believe-
like a great appeal to Northland, but I'm not sure what we do with it.
I think that's what happened in this case. I think an effective election was made by Audrey, and you can decide the matter on that basis. I don't even think you need to consider Northland Radiology because you're considering different parts of the statute and implicating other statutes. Also, we followed, or Audrey's was required under 3107D2 to provide her qualified health care coverage, which she did. I think under 3107D5, her election was correct and binding on all household members. Therefore, no coverage is available to her or anyone else. Because there is no qualified policy, because the opt-out was effective, 3114 does not apply. And in this case, 3115 applies because she was a pedestrian without an applicable PIP policy. That is our argument.
Do you have any questions? Judge?
Thank you.
Thank you. All right, now you have plenty of time for rebuttal should you need it.
I plan to use all of it. Very briefly, I'd just like to address 3115. Sister Council referenced the fact that this is a pedestrian accident as if this somehow changes something, and I don't think that it does. The plain language of 3115 says that except as provided in section 3114.1, a person who suffers accidental bodily injury while not an occupant of a motor vehicle claims under the assigned claims plan. But that except is really important here. 3114.1 provides that any resident relative claims under that person's plan or policy, and here there can be no dispute that there was a policy issued by Farm Bureau to Audrey Lusby, and it's as a resident relative, it applies to Isabella. I'm happy to answer any other questions, but I think Northland's very clear. I don't see any distinctions here. Otherwise, we'll rest on our briefing.
Any questions, Judge? Thank you very much. This case is submitted.
Have a good day.
Now you can have a good afternoon. All right.
You keep in touch with Miss Ruggiero? Tell her I said hello. Thank you. Okay. Thanks.
So the next case we're calling is 11, and that's 371-493 Robbins v. Robbins. And we have two people endorsed for oral argument.
Good morning, Your Honors. May it please the court, Steve Mack, I represent the defendant appellant, Steve Robbins. Want me to proceed or you want to put your appearance on?
No, you can proceed.
All right, thank you. With the court's permission, I'd like to reserve 5 minutes.
You've got it.
Highly unlikely that I'll use it, but nevertheless, we'll make that request. So I am very confident, given the few cases I've listened to already, that the court has had an opportunity to review our briefings. I did want to make a couple of points of order, if I may. I wanted to point out, and I think the court's aware of this, that there was no consent, judgment, or agreement between the parties that was incorporated into the judgment in this particular case. For example, I'm sure the court may or may not have heard of scenarios where a parent will agree to pay for college tuition for an adult child, which obviously has been found to be an enforceable agreement. You do not have that here. Instead, well, let me see how many years ago now. In 2008, when we litigated this matter over 4 days, that the issue of the life insurance policies, whole life insurance policies, was in fact litigated by the parties. And as a result of their disagreement on how to handle that, you'll see on paragraph 23, page 12 of the judgment of divorce has one paragraph. Very simply, it says the plaintiff and defendant are awarded joint ownership of the State Farm life insurance policies on the lives of Mark and Caitlin, period. There is no other language that says they would be third-party beneficiaries. There's no other language that indicates that when they become of age or adults, those policies are to be turned over to them. None of that was determined or ruled on, and I believe we all understand that a court speaks through its written orders, and obviously that is the entire paragraph.
Question for
Yes.
you. So the remedy of providing these directly to the kids you argue is improper, but was that paragraph adhered to at all? Like does mom have half
Ownership?
yeah.
So as part of the testimony that was taken at the evidentiary hearing, and it was also testified to at the trial, that State Farm did not permit more than one owner. So my client could not add her to it.
Now, can you remind me what was the evidence of that presented
There
to
was
the trial court?
Yes. So if in the transcript, the plaintiff produced an insurance expert who discussed the fact, as did my client, who is a State Farm agent, the fact that at the time State Farm would not permit more than one owner of these policies. So it was confirmed that there's this box that you check that basically only permits one owner of the policy. So that there was never any joint ownership that was added as a result of that. He couldn't do it. He simply couldn't do it. But again, nobody did anything for 13 years.
And you said at that time, has that changed or something?
No,
Okay.
it's still, no, there's nothing he can do about it. So, and then as I was indicating, it was not until 2021, so 13 years after.
Just a quick follow-up question.
yes,
So
yes.
you can't bring a court order to a State Farm agent and say, put my wife on this because
As far as we know, you can't force them to do something that their policy will not permit them to do.
But it has a value, right?
The whole life insurance policies,
The insurance policy has a value that the husband could compensate the wife for, could have done it at the time.
but yes, yeah, at the time in 2008, I think the cash value of one of the policies was like $400, and the cash value of one of the other policies might have been like $200. So yeah, could have, but obviously you've seen what the judge said as far as them continuing to be joint owners, and obviously after the entry of the judgment, my client was the sole person making the payments on the life insurance policy. But as we outlined, it wasn't until 13 years later, the judgment was entered on March 27th of 2008. It was not until 2021 when something was finally filed. And obviously you're aware of what Judge Tomlinson ended up doing and why we've appealed this. And so during that hearing, and when that issue was brought up, the issue of the whole life insurance policy was brought up. That's when Judge Tomlinson advised us that it was his belief that the children were third-party beneficiaries, even though that's not in the judgment of divorce. And one of the arguments we make opposing their argument regarding the statute of limitations, because I know counsel indicated that it didn't start till the children became adults. I believe that's one of his arguments, but that's nowhere in the judgment. And so it's our belief that under either of our arguments, the trial court needs to be reversed. And I just wanted to clarify that there was no agreement, nothing was agreed upon. The children were never listed as owners of these policies. And as my client testified during the evidentiary hearing and testified at the trial back in 2008, the idea is that the parents would own this, and depending on circumstances, they may or may not award that to their children at some point in the future. And of course, my client's argument was, if they're living a destructive life, for lack of a better term, you're not going to obviously turn over cash to your children if that's what they're doing. But the main point is that the trial court never made a finding that the parties would be holding these policies and turning them over to the children when they became adults.
Can you remind me whether or not your statute of limitations argument was preserved?
What do you mean? Like preserved? Like we argued it. It was the first thing we put in our answer to the motion when they filed it. We argued it at the first hearing and said, Judge, my goodness, this is 13 years down the road. Nobody's done anything. No one's came here and did anything. And Judge Tomlinson, I think he tries to be super fair. And in this instance, we think he went a little too far, because then we had discovery for 2 years after 2021. And honestly, the last time we were in court was, I believe, in 2026 recently, where he awarded legal fees for all the frivolous arguments that were made.
So you cited the statute at the trial court level in your response.
In our response, and I believe even in my oral argument, we re-argued the fact that, Judge, you got a statute of limitations issue. So, yes.
Now, this was a motion for reconsideration that was filed?
No, in 2021,
Yeah.
there was a motion filed to, quote unquote, I believe that was termed enforce the judgment of divorce or seek relief from the judgment.
So relief from judgment, that's what I'm
Yes,
sorry.
right.
So it's a relief, isn't there a 1 year,
Yes, there is. Yeah, that was one of the first things we talked about. We're like, 1 year from 2008.
and the divorce was final in 2008?
Yes, sir. Yes, it was 2008. But as I outlined, unfortunately, this is one of those cases that never died. After 2008, we had another 2 years of litigation in 11 and 12. And then in 13, we litigated again on the issue of equity in their Florida condo. And that's because it was 2008 when everybody lost all their equity. The judge had ordered my client to continue to make payments. And by the time we got to a point in the case where he could actually try and do a buyout, for lack of a better term, there was no equity. He had paid so much out of pocket that basically ended up with the house and the condo. So, and that's all I have, unless you have any questions for me. You've been very kind. Thank you.
Thank you.
Your Honor. John Adair on behalf of Mrs. Heine, currently known as Mrs. Heine. She is present in the courtroom. I first apologize to the court. I had my phone out. I missed Mr. Kevin's announcements before I walked in. So I apologize to the court and to Mr. Kevin. But I did discover a typo in my briefing on one of the cases I cited, the Milan case. I had the wrong, I think, page number for it, to the extent that it's relevant to the court. I cited it as 290 Mishap 291. It should have been 691. My apologies.
Thank you for the correction.
I'm just going to rebut a couple of the comments made in oral argument and rely on a brief, but to the point of this being not a consent judgment. I am fond of saying in this case that I've only been on it for about a year. I'm neither burdened by nor benefited by the long history that goes back to the case in 2007, 2008. So I was not present at the trial. I don't have obviously a memory of it, nor did I read the volumes of transcripts for it. There were numerous issues that were in contest during the course of this trial. This being, but the only remaining issue is this one issue, whether it was consented to or not consented to at the trial level, and then memorialized in the judgment. I think in the 2021 proceeding, Mr. Robbins admitted that, yes, he intended that these policies be for the benefit of the kids, that certainly admitted that Mrs. Robbins, now Heine, should have been a joint owner, which never happened, and that the kids should have been future owners. That's evidenced by him actually doing that for their other child, Heather, that he did change or transfer the ownership of that policy to her. that's an expression of his intent that it would have been done for the other two, but at the time they were minors.
I mean, they argued about everything. Like there was this whole discussion. Yes, I was going to transfer it when they had a family versus yes, he was going to transfer it the minute they became an adult. So, I mean, I think it's a little bit more complicated than that.
A bit maybe illusory as to the end, but the basic concept that it intended to go to the children. This, in this case, really isn't, our argument before the court isn't so much that it's a third-party beneficiary case. It's a contractual case between the prime parties that they were supposed to be joint owners. That didn't happen. I'm going to talk about the Farm Bureau issue that was raised. But it's clear in the transcript of, based on the motion that's before this court, that Mr. Robbins did in fact agree to it.
Extensive passage of time, wouldn't it just be to make the policy joint rather than to bring in the kids?
So if I may address the passage of time question first, because I think that was Judge Reardon's question about the statute of limitations.
I was going to ask you, no, I was asking about the motion for relief from judgment. It's a court rule at some point, 2.612.
If I could go back in time and represent Mrs. Heine at the time the motion was filed, I would have phrased this as a motion to enforce the judgment because it hadn't been enforced since 2008. So I think probably it's harmless error to bring the question before the trial court, maybe under the wrong court rule, because there is that 1-year limitations period on the. Correct. So I think.
Should we disregard the title?
Well, it was part of the title, motion to enforce, right? And I don't think there's a statute of
How about the
limitations.
motion for relief from judgment?
I think you can ignore the title. I think we're talking more about the substance of this the provision in the judgment to change to the joint ownership was not accomplished. And it wasn't discovered until shortly before Mrs. Heine's prior counsel did file the present motion. So I think that gets, that provides the correct forum for Mrs. Heine to ask the question. In addition to the other questions she asked, which have been resolved, which are not before this court. So as to the question about the State Farm's role, it's really an impossibility of performance question.
Wait, let's wrap Judge Reardon's question. So there's no statute of limitations problem under the motion for relief from judgment because it's not really one, substance over title and form and things like that. And but how is this timely, even if we consider it a motion to enforce? How is it not a statute of limitations issue?
Because I believe it was raised within a reasonable period of time after she discovered that the change had not been made. I don't know the exact time frame. I'm sorry, I don't know the exact time frame on when she discovered it versus when the motion was filed, but I believe it was less than a year. Can I answer your question about the State Farm role? Yeah. So really, if I could characterize them, it's really based on their argument is based on impossibility of performance because State Farm apparently has whatever rules that they say that they can't possibly follow the order of a court, or potentially mutual mistake that during the course of the trial it came up that they could be co-owners of the policy and years later discovered that they couldn't.
But an insurance policy is a contract, correct?
Correct.
So you're asking us to go in and modify the contract?
We're asking you to honor the substance of the judgment that would require.
So side agreement you're asking us to honor.
Correct. Because we didn't, during the course of this proceeding, Mrs. Heine did not sue State Farm for that. So I don't think that's preserved, but I think that this court can preserve the substance of the outcome is to have these life insurance policies. Judge Tomlinson said in his ruling from the bench that's outlined in this transcript that that he wanted Mrs. Heine to be a joint owner on the account for the control factor. That if there were going to be changes to the policy, that she would have to be a participant in those changes to prevent Mr. Robbins from changing the beneficiary, which in fact, subsequently, he did change. That's in the transcripts. I didn't cite it in my brief. He did change beneficiaries to non-children beneficiaries.
How much are those policies worth?
At the time, they were nominal. I'm going to say under $500. Mr. Robbins has added to them over the years. They have more value now. We say that that his additional contributions are irrelevant. He assumed the risk of making more contributions to them by not following the provisions of the judgment.
What's the value of them?
I don't know. It's probably in the court file somewhere. I just don't know off the top of my head.
Remand, because we're like, you can't involve a third party in this, but you do still have to follow the order. So, and it is in fact true that State Farm can't have two owners. Is the solution just that mom gets paid for the value in 2008, so a couple $100? Not to say that's nothing, but I'm asking if that's the solution.
I understand the question. I
Yeah.
think that is the practical remedy, is to remand and order Mr. Robbins to pay half of the value of the contract, as this has appreciated all these years, because he took on the risk of not having brought it to the court's attention when he learned that State Farm wouldn't split it. He should have brought that to the court's attention then. Instead, he ignored that, added to the value that Mrs. Robbins should benefit from.
So she's gonna get half today's value of it?
That's what our position is. Yes. Yes. I think I've answered all the questions that were raised during the presentation. Any other questions that the court has for me? Thank you so much.
Thank you. You have plenty of time for rebuttal.
Okay.
I like the very brief part, though.
Yes, of course. Every lawyer starts, right, by saying one more point. So just a point of clarification that my client wants me to bring to the court's attention, and that is he never owned Heather's policy, which is the policy council talked about. And he did in fact do what the court ordered, and that was turn over that policy to the mother when he was supposed to. That's all. Right. He wanted me to clarify that point for you.
Okay.
Thank you.
Nice and brief. Thank you.
Yes, thank you.
All right, that case is submitted. Have a nice day. So we're moving on to number 12. That's 371134 Craig Schubner versus CAN 4 Packard Square LLC. Right. Oh, I'm sorry. Thank you, Judge. And we're also calling case number 12-371134 Craig Schubner versus CAN 4 Packard Square LLC. And there's also the next case. We're going to call that as well. Is that just a?
The consolidated case.
Yeah, I see it. Okay, thank you.
Good afternoon, Your Honors. Elizabeth Parker, appearing on behalf of the appellant Craig Schubner in docket 371134 and appellants Schubner and 305 associates in docket number 377133. I would like to reserve 5 minutes for rebuttal.
Is it CAN or is it CAN?
Can is
Can,
how
okay.
I've always said it. I imagine it probably does stand for something, and it probably is CAN, but can works.
Very good. Just for my own clarification.
Certainly, and I don't know that I added to that, but so we do have the consolidated cases, which means I know we have several issues before the court and a lot of briefing, and I'm not going to repeat all of that. I would like to keep my comments real short and direct to the point. In first addressing the issues in 371134, Mr. Schubner is not asking this court or the lower court to relitigate the priority of the receiver loan or the amount of the deficiency. That has been resolved. This court already decided those actions. Rather, he brought an independent action under MCR 2.612C3, which does not have the 1-year limitation, based on certain admissions that were made by CAN 4's own witnesses that didn't exist until long after that guarantee judgment was entered and appealed, and all direct appeals had been exhausted. The action's not barred by res judicata or collateral estoppel because, again, that prior appeal was a legal dispute over contract interpretation and loan priority. This is a factual dispute over whether the affidavits that were filed in support had any evidentiary basis at all, which was never actually litigated because that evidence wasn't available. If we look at the trust factors, and I will rely on the briefing for the significant analysis of that, but 2 points I think are particularly important to recognize. Looking to the third trust factor, whether there was fraud, accident, or mistake which presented the assertion of that defense. Here, discovery of any receiver communications was fully blocked in both Washtenaw and Oakland proceedings. There were protective orders, objections to subpoenas, and quite frankly, the discovery of those particular admissions was not made until those persons were deposed in other actions in other states in some instances. Secondly, whether there was a adequate remedy at law. Again, the 1-year window had already closed by the time any of these admissions became available and could actually be used to support an independent action. I would argue that given those facts, the trial court erred in granting summary disposition. However, even if summary disposition was appropriate on the face of the complaint that was filed, it certainly erred in failing to grant the motion to amend. Futility really can't be assessed without letting that litigant put forth that proposed amended complaint and looking at those newly pled facts and letting them be tested in the course of litigation. And quite honestly, the response really doesn't contest that those admissions were made. It argues about what they mean. Well, we decide what they mean in the context of an independent action, which those particular admissions can be brought forth to the court, to the trier of fact, and can be tested. And so in that first matter, we would ask the court to either reverse the grant of summary judgment or the denial of the leave to amend and remand for filing of an amended complaint. I will turn to the second consolidated matter, 377133. In that matter, we actually present two independent issues. The first is following remand from this court, the trial court reached a conclusion that $1.5 million in debt shifted from 305 to Mr. Schubiner. And really that can't stand, again, if we look at the admissions of Can 4. That entire question is resolved as to whether or not there was a debt shifting by answering the question that the Court of Appeals on remand said it could not answer, which is what was the nature of Schubiner's debt obligation before the refinance. Up to that point in the proceedings, nobody had contested that Mr. Schubiner was obligated on the underlying note. Those judicial admissions, I believe, are binding. But more importantly,
But the extent to which the other party was relieved, you don't think that has any bearing here?
I don't, and I will explain why. Those admissions that I mentioned, they are reflected in the documents. So we know that in the accommodation rider to the mortgage, the security instrument secures a promissory note executed by Craig Schubiner. The trial court concluded that Mr. Schubiner only had, he was insolvent and there was only about $600,000 in debt before the refinance, and that had increased afterward. In fact, that isn't true. And what I think is outcome determinative on that point is the definition of debt under the Uniform Voidable Transactions Act. Debt is defined as liability on a claim, and claim as used in that context means, and again, this is a statutory definition, a right to payment, whether or not the right is reduced to judgment, liquidated or unliquidated, fixed, contingent, matured, unmatured, disputed, undisputed, legal, equitable, secured, or unsecured. So whether Mr. Schubiner was in fact the primary obligor or a guarantor in any scenario doesn't matter. Under the definition of debt, he held that debt both before the refinance and after. And so nothing changed except because of the refinance, his potential liability was reduced by about $100,000. So with his situation improved, and theoretically Can 4's ability to collect from him improved in that regard as well. And I think what the court—
But did their overall ability to collect improve? I mean,
sure. I mean, so the only way they get to collect, so to speak, on 305's assets is if there's if that one transaction is set aside. So the property was in 305's name, and it was after refinance, it's in 305's name. For one business day, it was in Mr. Schubiner's name, because as I understand it, the FHA will not allow a refinance in the name of an LLC. And so they always require that properties be held in an individual's name in order to process that transaction. And that's the concept of bare legal title that we talked about in our briefing. And it's recognized by Michigan courts. It's been certainly recognized by courts around the nation, the concept that, you know, if you don't really have legal title to it, you are doing this as an accommodation for the lender's requirements and it's immediately transferring back, then you have to look at that as one integrated transaction, which is what the trial court did in the first instance. And that finding was never set aside on remand. And so the idea that somehow we still have this integrated transaction, one transaction, but that Mr. Schubinar's debt changed is just not borne out by what I would argue are virtually uncontested facts. And whether you view him as a primary obligor on the note or you view him as a guarantor is not relevant at all under the Uniform Avoidable Transaction Act. He's got that liability, and that liability didn't change at any point. And so that one business day where he owned the condominium and then transferred it back to 305, at no point did his obligation on the underlying notes change. And so with regard to that particular finding, I would ask the court to remand with instructions that the trial court make, you know, explicit evidence-based findings on who was personally liable on that antecedent debt, because it didn't do that. And that was something that this court directly questioned in its remand opinion. Moving on to the final issue. And I told you I would keep it direct and straight and brief. And so hopefully I'm doing that. MCR 2.621G requires leave of the court for further proceedings. It is not limited to Michigan. It is not limited to the type of proceeding. It is further proceedings supplementary to judgment. And the reason being is because if you look at what that court rule requires, it requires the moving party to attest that they did not know about certain assets at the time they brought their first action. The idea is if you're going to do this, we're going to do it once. Because the court did not enforce that provision with regard to supplementary or additional actions that were filed in other states, CAN 4 has been able to avoid the impact of that rule. The argument that, well, we can't tell other states what they can do really fails, because we're not asking the court to tell other states what to do. We're asking the court to tell the party that's in its jurisdiction trying to enforce its judgment what to do. The court has in personam jurisdiction over CAN 4 and can direct it to not file further actions in any state without leave of the court. And again, the reason that's important is because they would have to make a representation about what they did and didn't know about certain assets. And if they can't meet that standard, then they can't just, you know, keep coming back to the well. You have to, the idea behind the court rule is if you're here, let's get it done. Let's not keep coming back. And unfortunately, what has happened is CAN 4 keeps coming back. We've had a multiplicity of actions in numerous states, some that they won, some that they've lost. And you know, it's this ongoing effort outside of the Michigan courts to collect on a Michigan judgment. I believe that the Michigan court has the right to evaluate whether those actions should be taken under the facts as presented under that court rule. And the Colorado court even acknowledged this. It said, you know, I may not agree that you in my Colorado court can rely on that rule, nor will I dismiss the action in Colorado. But the Michigan court has in personam jurisdiction and can exercise it there. And that's what we're asking the court to do, what we asked the lower court to do, and what we're asking this court to do. And so with regard to that second issue, we would ask the court to reverse the January 13, 2025 order and then remand for an entry of an order requiring CAN 4 to obtain leave before commencing or continuing any further supplementary proceedings to enforce the Michigan judgment, including compliance with that affidavit requirement, which is significant in this case. Unless there are questions, I will adjourn.
Judge Young?
Thank you.
Good afternoon, Philip DeRozier, appearing on behalf of Appellee CAN 4 Packard Square LLC, the appellee in both of the cases today. So I guess I'll start out with the 371134 case as well, and appreciating that all of this has been brief. So I will similarly try to keep my remarks short and touch on some of the things that have been brought up today. We do think that with respect to the relief from judgment case, that collateral estoppel and res judicata is key, even before you get to the attempt to bring an independent action. We know through both, and this goes back to the way the complaint was alleged, and how it was alleged is important because that was how the case was presented to the trial court. The complaint alleged that the receiver loan should not have been given priority in repayment, that it should have been the original construction loan. That issue was disposed of in Mr. Schubiner's very first appeal from the guarantee judgment. So that's what we refer in the briefing as Schubiner 1. That has been determined. It went up on appeal. It was affirmed. The $14 million deficiency judgment was also affirmed. And so we think you can stop right there. And it's just basically right, the purpose of res judicata. It's you should not be able to continually relitigate these issues that have been litigated time and again over the years. Now, turning to 2.612C3, that's a discretionary decision, whether to use the court rules ability to let a court overlook res judicata and collateral estoppel and pursue an independent action. And that's where the Trost factors come in. Trial court carefully explained why under 2 of the Trost factors, 4 and 5, there is not a reasonable basis to allow an independent judgment. Number 1, we disagree with the representations that Mr. Schubiner has made about the inability to pursue all of these various theories earlier than he has. It's with Mr. Schubert, it's a constant sort of evolving set of legal theories. Every time you think that a case is done, he comes up with a new theory, but it's never new facts. It's never really new evidence. It's really issues that were addressed. If there were additional facts or evidence that Mr. Schubiner thought could have been important, the opportunity to do that, that was then. Prior to the entry of the guarantee judgment. Even after, yet a year after, right, the guarantee judgment was entered. So, and that's 2.612C1, could have filed a motion for relief from judgment in the original case. Didn't do it. The trial court found that he didn't present any reasonable excuse for not doing that. And then that takes us to the 5th factor, which again, everything that's being raised, and this whole case comes down to this priority issue. What did CAN4 properly apply its credit bid first to the receiver loan? All of that was dealt with in the Schubiner 1 appeal. And so he had an adequate remedy at law, pursued it. If you think about what the courts that apply, the federal courts applying Rule 60D1 have said about when you allow an independent action, it's to correct an injustice, some fundamental failure of the justice system. And I just don't think that we can say that happened here. And certainly the trial court in its discretion did not believe that to be the case. Now, so that's the case as it was presented based on the complaint. Now, the complaint, the response to the motion for summary disposition, Mr. Schubiner's position at the time was, I'm not claiming fraud on the court. That was his response to the motion for summary. It wasn't until the motion for reconsideration that then, as kind of the par for the course, this attempt to sort of, all right, well, I lost, so now I've got to figure out a new way to come at this. And so that's where we get into this new fraud on the court theory that came up on reconsideration, and the alleged new evidence and whatnot. Motion for reconsideration, the trial court, this court has said time and again, does not abuse its discretion in denying reconsideration when what is being presented is new evidence and arguments that weren't presented earlier. And again, we think they could have been.
The court, am I correct in remembering the court made a finding that the new evidence, the alleged new evidence could have been discovered earlier? Was that part of the court's?
Absolutely.
Okay.
Yes. The court did. Yeah. The court disagreed with every attempt in the reconsideration motion to, suggest that this evidence couldn't have been brought up sooner. The other thing I just wanted to point out, and we addressed this in our brief, this whole fraud on the court theory, all of the same the Mason affidavit, the Goldman, or the Mason deposition, the Goldman deposition, the Julis deposition, all of those claims, all of that alleged new evidence was brought up in the Washtenaw County relief from judgment case that was filed by Packard Square. So Packard Square is the company that had the construction project. Mr. Schubiner is the owner. And this court had previously found privity. Everything that's decided against Packard Square is decided against Mr. Schubiner. All of these theories about new evidence were all brought up in the Washtenaw County Court, dismissed, and that was it. Now, and specifically including the extent to which the affidavits that Mr. Mason supplied in support of the receiver loans, whether they were supported by evidence, all of that, the attempt to get his deposition in, that was all done in the Washtenaw County case, and that was rejected. And that wasn't the first time in I'm going to call it Packard Square 3. So one of the Packard Square appeals, this case wasn't the first time that there was an effort to move on appeal to expand the record. Was done in that case too, specifically with the strategy of trying to bring this 2021 Mason deposition into that case. And this court in the Packard 3 case, which was, it's 348857 is the lead docket number. There was a motion to expand the record and it was denied. So all of this stuff about these, this alleged new evidence, it's been around for years. And the other thing I want to mention is, kind of putting under a bigger umbrella of just these attacks on the receiver and the receiver's misdeeds and the receiver, misrepresenting things, not having support. All of those things were again raised in the Packard Square 3 case. This court reviewed all of the same kinds of arguments, attacks on the receiver, and they were all rejected. And as I mentioned, including an attempt to show that the affidavits weren't supported by Mr. Mason by using his deposition transcript, which the court wouldn't permit. And then if you really go back in the history of this case, you'll see these attacks on the receiver go back 10 years. I mean, the receiver was appointed in 2016. That was appealed. All of this, that the receiver is in cahoots with CAN4, all of that stuff was raised and rejected. Now, we did address also the specific things that Mr. Schubiner cites as new evidence. And although I understand the position being, well, you can't look at the merits of that, I think you can. And we got into this in the brief, and I won't belabor it, but I think when you look at this new evidence, it doesn't even come close to remotely supporting, what the statements are about what it was said in those depositions. And so I'm going to just leave that there. With respect to denial of reconsideration, we touched on that, and then the leave to amend. Again, I think the leave to amend is based on what we see as just an untimely and ultimately meritless fraud on the court theory. It's stale, and so there's no basis to say that the trial court abused its discretion in denying leave to amend when, what was presented were things that were not raised previously. Now, I want to touch also briefly, and I know it's funny, people joked earlier about lawyers being brief. There was a judicial estoppel argument that we made as well that the trial court did not agree with, but I just wanted to mention that briefly. We do think that's an alternative basis to affirm. If you look back at sort of the way that this has all transpired, it's always sort of, CAN4 is always being sort of whipsawed. So there were two guarantees. We've been talking about the main guarantee that we have a judgment on based on the credit bid being applied to the receiver loan first and leaving a deficiency. So Mr. Schubiner used that state of affairs in the Sixth Circuit to evade liability under a separate guarantee, because the Sixth Circuit said, well, CAN4, you already recovered those amounts in state court under, this theory of having applied the credit bid to the receiver loan first, and that was affirmed, and so therefore you've already been paid essentially. So now what Mr. Schubiner wants to do is come in to Michigan courts and say, well, even though I escaped liability under that guarantee, now I want to also escape liability from the judgment on my guarantee, because really the receiver loan shouldn't have been paid off first, even though, again, as I've been saying, that issue has been litigated to death. So we do think that the principles of judicial estoppel apply to prevent that kind of gamesmanship. And so we would ask, that you consider that as, in sort of the bucket of reasons to affirm. That is really everything I wanted to say on the 371134 case. On the 377133 case, the fraudulent transfer, there was an evidentiary hearing and the trial court made findings of fact. Trial court made findings on remand from this court. This court in Schubiner 2 cited all of the same testimony from Mr. Schubiner that we've been talking about in our briefs about how the economic reality of the situation was that this liability was not his originally. This was 305's property. 305 was paying the mortgage payments. It wasn't until the refinance that, according to Mr. Schubiner's own testimony, was when he took responsibility for those payments. And that's where this debt shifting came from. The trial court alluded to found debt shifting in its very first set of findings in April 23. This court relied on those findings in Schubiner 2 and only remanded with one instruction, and that is because the court found, well, these were just refinancing transactions, so the debt shifting, kind of comes out in the wash. That's where this court said, no, that's error. You did not deal with the fact that $1.5 million in debt was shifted, and this is the court in Schubiner 2 telling the trial court this for the remand. So it goes back down. Mr. Schubiner had originally, when he was pro se, had attempted to expand the record. That was denied. Then he got counsel, and counsel said, we want you to make a decision based on the existing evidentiary record. And so that was made in March of 2023. It was 2 days of evidentiary testimony. And so that's what the trial court did. And the trial court made a finding, looked at the accommodation rider, looked at the mortgage language, Mr. Schubiner's testimony, and the court made a finding that of all of the UVTA factors having been met, that there was a debt shifting, and that resulted in a need to void the property transfer. And so then lastly, with respect to 2.621G, as we discussed in the brief, I don't think you need to go beyond the language of the court rule. The court rule says that if you have a proceeding supplementary to judgment under the court rule, you cannot commence further proceedings without leave of the court. Well, looking at that in context, further proceedings is in our view plainly referring to other supplementary proceedings pursued under the court rule. What Mr. Schubiner has done is what the Supreme Court cautioned against in the True Green case, which we cite in our brief. You can't pluck definitions out and say, well, this is how these words are defined. You have to look at the words as they appear in the rule. And so we think if you do that, every single subsection addresses some aspect of the procedure for supplementary proceedings under the rule. And so we think, as the trial court determined, it does not deal with collection efforts in other jurisdictions. The federal district court in Colorado looked at it the same way, said there's no way that can be how the rule is read, more or less. And so for those reasons, we would ask the court to affirm in both cases, unless you have questions.
Any questions, Judge?
I don't have any.
Thank you.
Thank you. So addressing the aspect of the argument about collateral estoppel and res judicata, there's no doubt that the initial complaint that was filed may have some factual allegations that should be stricken theoretically because they would not satisfy the standard. But that doesn't mean the entirety of the complaint is failing. And certainly, I believe that's why the denial of amendment was an error, because it was an abuse of discretion to ignore the significant omissions that were made by CAN4's representatives, which completely dispute what they said in their affidavits that the court relied on. The issue about whether or not it alleged fraud on the court or not, it's neither here nor there. The trust factors, one of the trust factors is whether you can demonstrate fraud, mistake, or accident. And so that is conceptually how fraud becomes part of the story here. But the allegation, you don't need to add alleged fraud on the court specifically in order to meet those trust factors. Although certainly I think, given the admissions, that standard could be met here. With regard to, the issue of whether wasn't Schubiner in privity with Packard Square, and didn't the Washtenaw County Court and this court already deal with all that? No, Mr. Schubiner was not a party to that action, first and foremost. It was dismissed on the pleadings without any discovery or evidentiary hearing. And it addressed specifically Packard Square's claims regarding the property. It had nothing to do with Schubiner's personal guarantee. And so I don't think we can look at it and say, well, good enough, because the very discrete, specific issues raised here were not addressed in that setting, nor on appeal in that setting. And the same thing holds true with regard to the Sixth Circuit opinion. That Sixth Circuit opinion didn't address the issue of whether the receiver loan should or should not have been paid off first. It didn't address liability issues on that. It actually dealt with the completion guarantee, which is an entirely different guarantee, and said, if you got the money or if you got the judgment under the receiver loan, then you can't get it again under the completion guarantee theory, because that's the same money. That's all. It didn't delve into whether or not there's any challenges available to the guarantee, whether the affidavits were sufficient that were filed, whether there's any evidence to challenge those affidavits later. And certainly as to the idea that the debt shifted, he was always responsible for 1.5 million. Now, whether 305 was paying it as an LLC versus him paying it makes no difference. If he's either a guarantor or primary obligor under the Uniform Voidable Transactions Act, that is debt. And that debt existed before the refinance, and after the refinance, it went down to 1.4 million. So his position improved. And to argue that, again, that one day of, you hold the property, so now, it's unencumbered and you're getting it, you're transferring it away from yourself. It was not a reality of the situation. And again, that uniform, unitary transaction, if you will, has been widely recognized. It's very common. I think it would really upend commercial transactions if there was a finding that, well, in the process of doing what are transactions that happen on a daily basis with refinancing with LLCs, a judgment creditor of the individual can come in on that one day and say, guess what? Now it's yours and you transferred it away, not for value. I think that defeats the whole purpose of what the point of the definition of debt and claim is in the uniform UVTA. I keep getting the language confused there. So I think, again, it's neither here nor there, whether he was a primary or a guarantor. It's all the same under that. And unless there are any questions, I will. Thank you.
Any questions? Thank you. Appreciate it. All right. That case is submitted. Both cases are submitted. Last case, number 13, it's 376936, Henry Witherell Miners, and we don't have anyone endorsed for oral arguments. That case is submitted on the briefs. And that concludes our case call for today.